Public versus private investigations. Knowing the rules and differences of each type. Public investigations. Public investigations are conducted by public law enforcement, federal, state, or local. This would include the local sheriff, state police, or federal agencies such as the FBI. These entities have certain rules that they need to follow when doing their investigations. First, they are bound by the United States Constitution. This protects against unlawful search, seizure of evidence. This also means the suspect also has civil rights that are protected. Usually, unless a case is of imminent danger to the public, requires a warrant to search and seize property in most cases. The warrant must be signed by a judge or magistrate and have written limitations and scopes. So the police cannot just show up and take everything. They do have some leeway if evidence is out in the open, but they need to stick to the warrant or the evidence may be thrown out in court. Public investigations have to do with criminal acts that violate local, state, or federal laws, and they are punishable by fines or by prison sentences. There are generally two federal laws that protect the suspect in public investigations. The first is the Fourth Amendment, which is the right of the people to secure their persons, houses, papers, and effects against unreasonable search and seizure. Shall not be violated, and no warrant shall be issued, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. The emphasis is mine. Law enforcement cannot just come in any time and take what they want and prosecute a crime. The second is 18 U.S.C. 2511. Interception and disclosure of wire, oral, and electronic communications prohibited. This prohibits wiretaps of phones and electronic communication without a warrant, so law enforcement cannot just eavesdrop looking for a crime. Private investigations are completely different entities and have a different set of rules. First, they are conducted by corporate or private security. There is no government involvement because it is usually related to breaking of policy rather than law. It could turn into a public investigation depending on the findings. Private investigations are generally conducted on corporate property, so no warrant will be necessary. This would involve office computers or networks. Most companies have in place a banner present to tell users that they have no expectation of privacy while using the system or network. This is how they protect themselves from civil lawsuits from employees. As I previously said, it is usually for a violation of corporate policy or rules as opposed to laws. The punishment will usually be suspension or termination of employment and not jail time or fines, since it is a violation of the company, not of the law. So what does this mean for you? First, in the corporate world, consult a lawyer about potential liabilities or have explicit policies in place for your actions if the target decides to sue. Corporate lawyers can advise on what you can and can't do. You only need to follow corporate policy and be able to cite said policy if there are any questions. Don't be a cowboy just because it's a private investigation. Also, along those same lines, if you are a corporate and you think that the case may turn criminal, stop and call law enforcement and bring in your corporate lawyers who can advise you legally. Examples is the computer repair shop that finds explicit pictures on the computer. If you don't report, you are legally responsible for this and may be breaking the law. If you are a law enforcement officer, you must have a warrant. If your evidence is critical and gets thrown out because of poor planning on you, you've wasted everyone's time and a potential criminal got off the hook. There are warrant exceptions but must be used carefully. Know the law and how to apply the exceptions for each case and consult your chain of command about how to proceed.